In a courtroom, we frequently see expert witnesses, but how are experts different from other witnesses? I'm Dan Ringer, and we'll talk about experts right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
What makes a witness an expert, and what does that really mean? My guests are attorney James Mulhall and George Wharton, a licensed professional engineer. Jim, George, thank you for coming in today.
Thanks for having us. Yes.
We talked about expert witnesses. What is an expert witness?
An expert witness is a person who, based upon their background, education, and experience, is allowed to give testimony that would be helpful to the jury, to help the jury come to a better understanding of what the case is about, and possibly come to a conclusion in the case.
The jury's job is to evaluate facts. We often say the judge is the trier of law, the determiner of law. The jury is the determiner of facts. So the expert is to help the jury understand the facts.
Correct.
Or
yes.
at least the facts that apply to the expert.
Right. The facts, the expert would be talking about things that would be relevant and reliable so that the jury can better understand the facts like you're saying. And the judge takes the first step to make sure that what the expert is going to talk about would hopefully do that. It would hopefully educate the jury and give them a better understanding about the facts.
The judge qualifies the expert as an expert.
That's correct.
In fact, George, that's what you do. You're a professional engineer, a mechanical engineer.
Yes.
You frequently show up in the courtroom as an expert witness.
Yes.
When you get on the stand, you're just George Wharton.
I am, until somebody gets to ask me questions about my qualifications, background, and what makes me able to provide an expert opinion.
We call that voir dire, or qualificate. What do we call it?
Proffering or qualifying an expert.
Okay. So what kind of questions would I ask George to convince the judge to allow him to testify with expertise?
With George's background, you'd want to get into his education, what his relevant experience is, whether he has done testing or any type of research relative to the issue in the particular case, whether he's investigated the matter at all, whether he has read about the matter, and maybe whether he's done any publication that may have been peer-reviewed on the topic.
Whether you're well regarded within your profession.
Exactly.
Won awards, given lectures, taught classes.
Yes. But all those things can come with a downside too, because if it doesn't support your opinion in your background, that can be dangerous.
Well, there's a phrase in the computer business, it's garbage in, garbage out. And you are an arbiter of the information that you are given.
Yes. And hopefully you're given it all.
The way you said that, it makes me think maybe once or twice it's not worked out quite that way.
Yeah, you don't want to be surprised when the attorney hasn't divulged everything to you before you make your opinions.
Well, in fact, as we're meeting to do this show, I had just heard this morning, anecdotally, about a murder trial where the defendant was saying that she didn't remember the events that led to the killing of the deceased. She was on trial for murder because of the trauma of having been attacked by a bunch of people and sexually abused. And so when she killed her boyfriend, she couldn't remember it. And the psychologist got on the stand and testified that, yes, this is a good basis for post-traumatic stress syndrome, and that would affect her memory. And the prosecutor on cross-examination pointed out that, in fact, she was not attacked by a group of people and sexually abused, that there was only one person ever there, and that was the guy she killed. And the expert's testimony just imploded as a result of that, because he had not been accurately told what the facts were to set up the scenario for his opinion.
And nobody was more surprised than that expert.
I suspect that's true.
And the jury would then, hearing what the expert had to say, be the people who would decide how much credibility to give what the expert said.
And in fact, on some occasions, a judge will say, disregard that because it's not competent to the issue in trial here. If you say the building blew up and it actually blew down, there's a big difference between those two things.
Right. The most important thing is you have your facts straight.
Where do experts come from?
They can come from a whole wide variety of areas. It would be, they don't have to have a particular degree. They don't have to have particular backgrounds or experience, but it's really an accumulation of their background and possibly their education that the judge would consider when the judge is thinking about whether to declare the person an expert. It could be a person that has on-the-job training, or it could be a person that has an advanced degree.
How high is the hurdle that an expert has to get over? That's a figurative hurdle. We don't actually make them jump hurdles. How high is this hurdle that the expert has to get over to be an expert?
The general idea, the general thrust, is to allow a person to be declared an expert if there is a sound basis for doing it. So it's up to the judge. It's in the judge's discretion based upon the information presented to the judge. But the main thrust is to try to allow the person to be declared an expert. And then from there, the judge can limit what the expert would testify about. And as we said before, the jury could give the credibility to what the expert has to say.
And when we say give credibility to it, the jury can decide how important the testimony is, whether it's something of monumental significance or whether it's a rather picky-unish little detail.
Right, absolutely, Dan. It would be how much the jury wants to give credibility, how much weight they want to give to what the expert said, and whether they're going to consider it during their jury deliberations.
Experts can testify about big issues or about very small issues. I once used a PhD physicist in a case to testify that when you're reading water levels, it can only be as accurate as halfway between the two marks that you're measuring water level. It says 1 foot and 2 feet. You can only opine to the nearest half foot because there are no finer gradations on that. That's a pretty small detail, but in the context of that particular case, it was a very important detail.
And people could have a different opinion on that too. When I was taught, you can read to within the gradations, you can estimate to the nearest tenth.
And we used to use slide rules where we had to do that.
Right,
and we
exactly.
sent people to the moon doing that.
Exactly.
We're talking about expert witnesses. My guests are attorney James Mulhall and George Wharton, a licensed professional engineer. I'm Dan Ringer, and this is The Law Works. When do you start, as you're a trial lawyer, when do you start thinking about experts in a case?
A lot of times you think about them from the beginning. If an expert is retained closer to the beginning of the case, an expert can be used to help all the parties involved understand the case. The expert can provide insight that the attorneys or the individuals involved in the action might not think about. And the expert can be very helpful in providing insight and maybe giving information about areas that the attorney wants to further explore.
Contrary to popular belief, lawyers don't know everything. And we have to be educated about the case that we're dealing with.
Right. Their experts are a fantastic source of information. They can bring someone up to speed pretty quickly about their areas of expertise, and that's also another factor in the expert that you're thinking about, making sure that the expert is a good communicator, because that's what one of the things is that you want to get across at the time of trial if you're using the expert at the time of trial.
Is that the way you prefer to be used as an expert? Get involved early?
Absolutely. There's times where we're even involved before the attorneys. I mean, we sometimes do first responder type of investigations where we might be hired by an insurance company or even a self-insured company to investigate an accident right after it happens.
I have had occasion many times to recommend to mom and pop, if they come in and they think they might want to sue somebody or they have a cause of action against somebody, I've had to advise them, you need to get such and so an expert. And usually in small mom and pop kinds of cases, what you're looking for is a construction engineer or sometimes just a contractor. But you say you have to hire somebody to come in and tell you that this was done incorrectly or the materials that were used were the improper materials or bad materials. And that's greatly discouraging to them. Having an insurance company hire an expert is one thing. Having the widow that lives next door hire one is a very different thing. It is time consuming to be an expert.
It is. It's a daunting task for an individual to hire an expert. Experts can be expensive, and if you don't hire an experienced expert, if they're trying to find their way on your dime, that can be very frustrating.
And experts don't grow from trees.
No. You asked earlier, where do experts come from? Many of them, like me, for example, I'm a professional expert. That's what I do full-time. I investigate accidents and offer opinions full-time. And it's almost that I'm an expert on being an expert. I can learn about the facts of a case in preparation, but knowing the process is just as important as knowing really the technical expertise.
One of the areas that people frequently see experts in, but they don't realize it, is when they go to have some kind of surgical procedure performed or some sort of ailment diagnosed. And they will say, well, the doctor only saw me for mumble number of minutes. And sometimes as short as 20 seconds. The typical meeting with a physician during the course of a physical examination is about 20 minutes long because aides and physician's assistants do the rest of the work. But for the doctor to evaluate you after a 1 minute, 15 minute, 60-minute meeting, she or he may well have spent hours reading about the current state of that type of matter.
Yes.
And an engineer would have to do the same thing.
Exactly, yeah. Figure out what standards apply, all kinds of research that can go into the background to form an opinion.
And there might be recent testing or recent studies that have been done on that particular issue that the expert might have read recently about that might be helpful.
Well, if experts are so expert, why is it when we get into a courtroom, each side has their own expert and they talk about different opinions?
Each side is entitled to have an expert if the judge permits it, and opinions can differ. The one side could get an expert that through their education and training believes that a set of facts leads to one type of conclusion, and another expert with similar qualifications can come to a different conclusion. And it's really up to the jury to decide what the jury thinks.
What do you think when somebody else with your comparable qualifications gets up and says something completely different?
Well, I love that part. It's almost like jousting. My ideas against your ideas, and it's a team between the expert and the attorney to present the best case. The facts are often open to interpretation, and ultimately it is the jury that decides, but the expert gets to help the jury, help convince the jury in one direction or the other.
One of your particular areas of expertise is fires and explosions investigations. Mm-hmm. And there is a lot of room for different opinions in that particular area.
It is. There is a lot of room for different opinions. There's many many fires are accidental in nature, and then trying to pin down a cause, that's open to a lot of debate.
So it's not just black and white all the time.
Not usually, yes.
Well, you and I are involved in a case, Jim, and you tell me, well, I'm going to use George Wharton as an expert. Do I get to talk to him?
Yes, you do. You would certainly be able to talk to him. You could talk to him on your own terms. In other words, if you want to talk to him as a consultant so that you talk to him and the two of you have a conversation, maybe you learn about what he has to say, you can do that. If you also want to talk to him and want to possibly use him at the time of trial and put him up as an expert in the case, you could do that as well.
Do I get to do that even if he's going to be your expert?
No, not if he's mine.
You are on opposite sides of the case.
Yes, we're on opposite sides of the case.
Yes, okay. No, if he is on, you are not permitted to talk to the expert on the other side of the case except through formal discovery processes and while the retaining attorney is involved.
Okay. We're talking about expert witnesses. My guests are attorney James Mulhall and George Wharton, a licensed professional engineer. I'm Dan Ringer, and this is The Law Works. So you give me notice that you're going to use George Wharton as an expert. What am I entitled to know about him?
You can find out about his background and what his opinions are and the basis for his opinions. You can find that out by way of written discovery where you ask written questions. You also are entitled to have a deposition where you can sit down and ask him questions under oath to find out what his opinions are and what testing he did and what the relevancy is of what he's saying.
And I can have then my own expert review all of that and tell me whether he, she agrees with George's opinion or whether they have a different opinion. What happens, and this does happen from time to time, you hire an expert, you say, here's all the information. They tell you that that's not enough, they need more information. That happens a lot. And at the end of that, they look at it and say, Jim, you're in trouble here because you're trying to defend this case or prosecute this case, and I just don't see anything here to support your side of it. Do I then get to know that he told you that?
Well, it depends on how you've disclosed the expert. If you have retained the expert as a consultant, then no, not necessarily. I mean, if you've put them up as an expert and you're finding that information out at the time of deposition, then the other side would get to know that.
So really the seminal point is when you designate George is going to be my expert witness, now I'm entitled to know what he has to say, even if it's adverse to your case.
Yes.
Although you wouldn't have noticed him as a witness if he was going to be adverse to your case based on what he knew at the time.
Right, right.
And I have an ethical responsibility to keep track of everything I've done on the case and make that available for review if I do get disclosed.
So if you support his side of the case, he discloses you, and then you're able to tell me how, what, why, when you did all of these things.
That's correct.
So not all experts testify in court.
No.
That's correct.
Only the helpful ones.
Well, I wouldn't put it that way. If an expert's giving you information like that, you might have other troubles as well.
Well, lawyers are sometimes surprised by what experts say because we find out that we have not been the best of communicators. I said lawyers don't know everything. They don't necessarily form or function well as teachers either. And that's what you have to have, is you have to have somebody teach you about the facts of the case, make sure that the things you're given are all of the things that you need.
Yeah, completeness is critical because if the attorney withholds something from me because he's afraid of what I might think about it, and then I'm faced with it and it's a surprise when I'm testifying, that, as Jim said earlier, that really undermines my credibility with the jury. They go, why should I listen to this guy? He doesn't even know all the facts.
There are some standards, though, that an expert's testimony has to meet before it's allowed to come into the courtroom. Becoming qualified as an expert is one thing. Having your opinions accepted as expert or admissible expert opinions is another. How do we determine whether what he says gets into the case?
The judge makes that decision. If the judge does decide that the person is qualified to be an expert, the judge will listen to the arguments of the opposing counsel, if there are any, and try to decide whether the testimony is, among other things, relevant and reliable, and if it's based on sound testing criteria, if it's been peer-reviewed. There are various criteria that the trial judge would consider when the judge is determining whether to make the testimony admissible.
That is determined by what has come to be referred to as the Daubert test.
Right, yes. In this jurisdiction, that's essentially what the test is for considering whether an expert is to be declared an expert.
That all comes from a case called Daubert versus Merrill Dow Pharmaceuticals. And the facts of that case are not terribly important to our purpose, but it was a federal case, and the United States Supreme Court came out and said, here is what the information has to be, what the standards it has to meet. And they said the expert's scientific, technical, and specialized knowledge has to actually help the jury, the trier of fact, to understand the evidence and determine a fact and issue. You can't just get on the stand and baffle us with BS,
Right.
the way we would say it.
There's many parts to that standard. It has to be reliable information you're providing. It has to be a methodology that's approved within your community of research, if you will. Oftentimes, it has to have been peer reviewed. There has to be, if there's testing and there's a measurement, it has to have a known potential for error. There's many aspects to it that say whether it's reliable or not and can be presented to the jury.
What's peer review?
Peer review is oftentimes when someone publishes in a trade magazine or just a scholarly article that gets picked up and published. It means that other people can review that what you say you went through in your testing and the results that you achieved, and it's open to criticism, so that somebody can challenge it.
And things like this happen frequently. Usually we think of these things being discussed in academic journals where there is a panel of independent experts, typically scientists in the same area, who look at it and say, you did this wrong, or your measurement's not accurate, or that's impossible, here's why. Or somebody tries to reproduce the test that you did and they come up with the same result. Then it's said to be reproducible. That's good.
Yes.
If they get a different result, that's bad.
And many times there are challenges based on contradictory results, and we see this all the time in medicine, for example, where there'll be a test that's rolled out and it says helped 4 out of 5 people, and then later, years later, they'll say we've got contradictory evidence about that issue.
And surprisingly, things that we have accepted for years and years and years as being accurate are subsequently shown to not be accurate.
Is red wine good for you?
How about eggs?
Right.
Is eating eggs good for
Right,
you?
exactly.
Whole fields of study, like phrenology, which I think is studying the bumps on one's head. We made all kinds of forecasts and conclusions about that, and it was, by current thinking, just a load of hokum.
Mm-hmm. And that idea does carry over into various areas. So for the scientific side of things, when Daubert is used for the scientific analysis, part of the consideration could be the state of the art. I mean, what was known when, and if the information is changing over time, that could be a part of the entire consideration.
Well, in criminal law, we have been faced with that directly through the use of DNA. Not only has DNA testing improved over the years, and it's now considered to be really, really fine until next year when we find something that's better, but it supplanted a whole different area of testing, which was not as accurate. Well,
and like the polygraph test is still at issue as far as whether it's admissible or
there's a
not.
lot of science behind it, but we still haven't decided whether it really, really works. Jim Mulhall, George Wharton, thank you, gentlemen, for being with us.
My pleasure.
Thanks.
On behalf of the LawWorks, thank you also for being with us. I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes.
The LawWorks is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the LawWorks is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.